This is Michael Popok, Legal AF. Were you wondering what the Department of Justice really felt like when this United States Supreme Court dropped its immunity decision against them on July the 1st, basically declaring absolute immunity under a separation of powers doctrine? All you need to know is in a new filing by the Department of Justice against the Heritage Foundation and Tom Fitton, that non-lawyer who runs Judicial Watch, and their efforts under the Freedom of Information Act to try to get their hands on the actual audio recordings of President Biden's interview with the special counsel, his special counsel that was interviewing him related to the retention of national security information and top secret information. The transcript of that interview has already been made public in its entirety. The 300-page report by Robert Hur, the special counsel, with an asterisk, apparently. According to MAGA, special counsels don't really exist. They're figments of our imagination. They haven't been properly appointed or funded. But leave that aside for a minute. There was a special counsel, which suddenly they're all excited about. You know, the one against Donald Trump in Mar-a-Lago, that one is illegitimate. But Robert Hur, a Republican appointed by Merrick Garland to go after and investigate Joe Biden because they liked some of the things he said in his report, oh, that special counsel is just fine. And so how I know the Department of Justice is not going to acknowledge that case law that was just that new precedent just established by the Supreme Court that said that under a structural separation of powers analysis, the executive branch has to rise above it all and be an imperial president with almost absolute immunity, is because they didn't cite to that at all for any of the propositions in their new 40 or 50-page filing in the District of Columbia to try to beat back the Heritage Foundation, who's also the architect of Project 2025 and the Agenda 47 for Donald Trump, and Tom Fitton, who runs around playing lawyer with super tight polo shirts. You know Tom Fitton, generally loses over and over and over again. Tom Fitton and Judicial Watch loses so many times in their court filings that you can just cite to their losing cases against them when you are filing your brief. You can just have an entire citation table of just Judicial Watch losses in proving your case against Judicial Watch. That's where we're at. And so I went through this new filing because the Department of Justice has filed a special brief arguing that there is no Freedom of Information Act right, FOIA Act right, to Heritage Foundation or CNN or anybody else to get their grubby little hands on the audio recordings of Joe Biden. And they say it's for a number of reasons. There are a number of built-in expressed exceptions to FOIA, for instance, that prevent this. One, exemption number 5 says if there's any civil litigation privilege, it can be invoked appropriately. And that includes, and there's a legion of case law, including against Judicial Watch, that says an executive privilege, which is the privilege held by a president of the United States, is just such a civil litigation privilege that can be properly invoked to stop the production of those records. Done. Section 7, or Exemption 7 of FOIA, says if there's an ongoing criminal investigation or ongoing investigation that this could hamper or interfere with, it's another reason not to produce the audio. And even though the transcript is out there, it is obvious that and I'll read to you from the new filing, the Department of Justice has ongoing criminal investigations that could be compromised by the release of the audio. And the third major reason is a right to privacy, but more particularly national security interest of not having an audio version, an exact audio version of our president's voice and voice patterns being released to the public. We're in the world of deep fakes. I know Donald Trump keeps confusing it and calling it cheap fakes, but we're in the world of AI-driven deep fakes. All they got to do is take that audio, run it through a computer and artificial intelligence and algorithms, and they can get a Joe Biden to say and do anything. How about at the moment when he has to clearly say something on the phone to his counterpart overseas or to Putin or something? Instead, an interloper comes in, intercepts it, and does another fake Joe Biden that says he's going to be doing something drastic against that country. We wouldn't want that to happen for Biden or any other occupant of the Oval Office. And that's another reason. And judges have already confirmed this over and over again in rulings against Judicial Watch on these very points. So I love the incongruity, the inconsistencies that always are replete every time we see a filing by Heritage Foundation, which is run effectively by former Trumpers who have formed a shadow government, and Judicial Watch. It's just, we don't like special counsel because they're illegitimate until we like special counsel when it's against Joe Biden. Yeah, and the Department of Justice, as I said at the top of the hot take, they avoided very carefully ever referencing Trump versus U.S., the ruling in July. Every one of their citations about separation of powers and why executive privilege is applicable cites to a Nixon line of cases, goes back to the 70s, and avoids completely what just happened on July 1. So the filing here, which I have in front of me, and I'll read certain pages from you, is defendant U.S. Department of Justice. They're the defendant in the Freedom of Information Act case that's been filed, is the opposition to plaintiffs' motions for summary judgment and reply to summary judgment. In other words, Tom Fitton's group and Heritage Foundation have said we don't even need a trial on the undisputed facts. We're entitled to the audio of Biden, and it doesn't satisfy Exemption 5 or Exemption 7 of the Freedom of Information Act. Now, this case is presided over by, let me make sure I get my notes right, is presided over by a judge who was appointed, Judge Tim Kelly, who was appointed by Donald Trump. I mean, he had served with a certain amount of valor and success in the public integrity unit of the Department of Justice, which is where Jack Smith actually served some time as well. He's also had been the chief counsel for national security issues for Republican Chuck Grassley out of Iowa. And so he kind of got confirmed relatively quickly back in the first part of Donald Trump's 2016 start to his administration. But he's ruled against Trump and against Jan 6ers ever since. He ruled against the Proud Boys that he presided over their trial, didn't dismiss their indictment, and they got convicted of seditious conspiracy. He's ruled against Donald Trump in his attempts to bar Jim Acosta, the CNN reporter, from press briefings, allowing him to continue with his press credentials until the trial. And then eventually that got Jim Acosta's press credentials back. So even though appointed by a MAGA in Trump, so far he's been calling balls and strikes. So I'm not that concerned about Kelly doing the wrong thing. I think the way that it's been laid out by the Department of Justice in their briefing is right about the application. Let me just read to you Section 5 or Exemption 5 we've talked about of FOIA, which is the executive privilege under the separation of powers doctrine is supreme and allows it to be exercised against a FOIA request, meaning Biden has asserted executive privilege and therefore the audio should not be given out over that privilege. And any argument that somehow Congress can interfere or roll back or infringe on a privilege given to the executive branch would be a violation of separation of powers and our structural co-equal branches of government. And so they make that argument. And then when the interesting thing about the filing really comes down to page 25 and 26, in which they're talking about a loser Judicial Watch case itself. And they go on at top of page 26, the Department of Justice, to say the audio recordings have never been publicly released. Plaintiffs' express purpose in this lawsuit is to force the disclosure of this non-public law enforcement information. And the D.C. Circuit has explained why the release of an audio recording can reveal new and highly personal information that is separate from the information contained in a written transcript of the proceeding, and the government accordingly can withhold an audio recording under FOIA, Freedom of Information Act, even after release of its transcript, citing a case involving NASA, citing back in 1991. In short, it continues on page 26, in short, there can be no doubt that disclosure of the audio recording will result in the release of new non-public information that implicates important privacy interests under controlling precedent. They also talk about the harm in personal information that's in the law enforcement file. Particularly, they talk about the issue, let me just turn to page 26 and 27. On 26, they say, plaintiffs attempt to argue that the public disclosure of an audio recording of an interview with a prosecutor who is trying to determine whether the interviewee, in this case President Biden, committed a federal crime and who determined that charges were not warranted would not have a meaningful impact on President Biden's privacy. That's the argument. Some of plaintiffs go so far as to suggest, this is on top of 27, that President Biden does not have any privacy interests relevant to the publication of such a record. This is what the Department of Justice said in response to that. In the department's opening memorandum, the department noted that if the audio recording were ordered disclosed, it would be disseminated worldwide, be universally available on the internet, and played on national television. None of the plaintiffs dispute this, nor could they. It would be the obvious result of a disclosure order. Plaintiffs themselves suggest that the audio recording would be held up to prominent and widespread scrutiny so that the public could try to draw inferences from the sound, tone, and pacing of President Biden's responses to questions from the special counsel, and thus allow public commentary on whether President Biden should have been charged with a crime, even after the prosecutor determined charges were unwarranted and explained why in an exhaustive public report. To say that such a disclosure does not amount to a meaningful intrusion on personal privacy is to suggest that Exemption 7C's supposed emphasis on protecting privacy has no meaning at all. And then they go on to say how dangerous it would be to have a president's voice itself be able to be released to the general public, intercepted, used improperly, corruptly, and through artificial intelligence and the rest. So that is the filing that's now been made. This is the terms of the brief. This is the opposition brief. Judicial Watch, Tom Fitton's nonsense organization, and CNN and Heritage Foundation will have one last brief. I expect that comes in the next couple of weeks. And before the end of July, beginning of August, it'll be fully briefed. There may be an oral argument in federal court. That doesn't have to be an oral argument or hearing. Judge Kelly can make the ruling on his own on the briefing. And whoever the loser of that decision is will most certainly take an appeal. If it's the Department of Justice, they will be taking appeal to the D.C. Court of Appeals. And again, that audio recording will be withheld until the time of the appeal. I mean, even if Kelly ruled against the Department of Justice and made it and ordered the audio be disclosed, I'm sure he would stay his order to allow for the appeal. That's sort of his way, and that's how this has been playing out in places like the D.C. and D.C. Courts of Appeal. So I expect that to happen, and there'll be an appeal. I don't see it as an emergency appeal. I think it'll take a normal course. It'll take us over 2025, and they have to be very careful about the precedent that they're setting. Now, this is not just about Joe Biden. This is about the office of the presidency, the assertion of executive privilege, its use against the Freedom of Information Act request, the impact on law enforcement, ongoing law enforcement proceedings, the right to privacy of the occupant of the White House, and all of these exemptions. So if they're going to make new law, and they're not going to be consistent with all the law that's been cited ad nauseum by the Department of Justice, then they better be very careful in making that new law because it applies to Republicans and Democrats alike, regardless of who's in that office. We'll continue to follow this attempt by MAGA, ultimately, to get their hands, their grubby little hands, on the audio recording to do whatever mischief they plan to do, to slice and dice it, just like they did the video recordings in Georgia of the vote counting that they used improperly to suggest that 2 election workers were committing crimes, and which was totally untrue. They're going to do the same thing with the audio. There's no doubt there is a nefarious purpose behind. When I see Heritage Foundation and Tom Fitton's Judicial Watch, it's like, look out, nothing good is going to come out of this series of requests. And that's why we have exemptions to FOIA. And if the Supreme Court doesn't like it in the next term, they can rewrite FOIA, just like they've rewritten all the other precedent that's out there. But until that time, there's a body of law in the District of Columbia and the D.C. Courts of Appeal that needs to be applied, and to restrict the use and the dissemination of this audio recording of this interviewee who happened to be President of the United States at the time, willingly cooperating with a special counsel. And note to Fenton and Heritage Foundation, I thought special counsels were illegitimate. Here, you like the special counsel and you want to get a copy of his audio recording of his interview. Let's get consistent here, right? And stop flip-flopping on positions that you're taking in the various courts. We spot them, we see them, and we're talking about them here on Legal AF on the MeidasTouch Network. Join me on Wednesdays and Saturdays at 8 p.m. Eastern Time. Now you know why we call it Legal AF. It sits at the intersection of law and politics, the leading podcast that does so. It's lawyers talking about things. They know what they're talking about. And we curate the top 4 or 5 stories. It's an hour-long podcast. If you don't like that, we do hot takes like this about every hour on the intersection of law and politics. And then we have other versions of Legal AF, including audio podcast versions that are out there. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.